Since before the last presidential election, we have seen unlawful private militia groups presenting a threat to public safety and to democratic participation. Whether attacking the Capitol on January 6th or purporting to engage in law enforcement, surveilling ballot drop boxes, showing up at demonstrations and rallies and ordering people around, standing sentry at county board meetings. This armed vigilante activity is unlawful. There are 3 points you should remember. First, there is no federal or state authority for private individuals to create their own private armies. They will sometimes point to the words well-regulated in the U.S. Constitution and in the language of most state constitutions. But well-regulated has always meant, since even before the founding, regulated by the state, regulated by the government. Second, private militias are not protected by the Second Amendment. For all the gray areas about what gun regulations are protected by the Second Amendment, this is not one of those gray areas. As far back as 1886, the Supreme Court upheld a law, still on the books of 29 states to this day, that barred bodies of men from associating together as a military unit or military company or parading or drilling in public with firearms. The Supreme Court said, in upholding that law, that it was necessary for the state to be able to prohibit private paramilitary organizations in order to protect the public peace, safety, and good order. Fast forward to 2008, when the Supreme Court held for the first time that the Second Amendment protects an individual right to bear arms for self-defense, the court pointedly contrasted that right with private paramilitary organizations, reiterating its holding from 1886 that the Second Amendment does not prevent states from prohibiting private paramilitary activity. And third, all 50 states prohibit them. Nearly every state constitution provides that military units within the state must report to the governor, and that the only lawful militias are the National Guard and other state-authorized defense forces. Other states have laws like the one upheld in 1886, or prohibit paramilitary training or unlawfully assuming the functions of law enforcement. So if you see unofficial armed paramilitary organizations, militias you might say, engaging with the public, usurping the role of law enforcement, deciding when and under what circumstances they'll deploy lethal force, that is illegal. Use this QR code to get to ICAP's resources on voter intimidation, unlawful paramilitary activity, and other guidance for protecting public safety and constitutional rights.